Welcome to Dorsey and Whitney's webinar on FinCEN's beneficial ownership information rules under the Corporate Transparency Act. Are you ready? I'd like to introduce Joe Liniak, a partner in Dorsey's Finance and Restructuring Group. Joe?
Oh, good afternoon, everyone. This is Joe Leniak speaking. Thank you very much, Laurie. And before we start, I just want to go through a few housekeeping issues. While the information we're going to be talking about today is very, very important for business people and management people who are non-lawyers, the content is very regulatorily oriented. And so we're able to give CLE credit. And for those of you who are lawyers and want CLE, that is available in the states we've noticed here. In some states, it's a super secret code, which we've got to give, and I think Aaron Bryan will give that to you in a few days, in a little bit, in her portion of the presentation. And there's a form which we'd like you to fill out, which is certainly helpful to us. And here are our panelists. Erin Bryan, who is my partner, and she works together with me on bank regulatory issues and financial service regulatory issues. Matt Dickerson, who is a corporate associate, and many of the issues we're going to be talking about today are going to devolve down to corporate practice. And he has been very, very active in working through all of these issues that we have been discussing. And myself, I'm just an old fogey who wanders around occasionally and worries about these regulatory issues. As an agenda, we're gonna take it in segments, presenting first a general overview of obligations for so-called reporting companies, and that's an important term, commencing as of January 1st of 2024, including identifying foreign and domestic covered entities, which is important. If you're covered, you've got these reporting responsibilities. Whether or not exceptions apply, and there are many, many exceptions, but not for smaller companies and new startups. So again, it's important to look at these issues. Who are beneficial owners, which is a significant expansion of where it was prior to the adoption of the new statute. Company applicants, which again is a new reporting issue which you need to understand. Timing requirements, filing requirements. If you've got a report, what do you need to put in your reports to FinCEN? And then we're going to end up with recent developments to give you an idea of what we have been dealing with FinCEN, trying to get information from them. And again, so we're going to start out with a general overview, and then Aaron Bryan is going to go into very, very significant detail about who is covered, why are they covered, what are the exemptions. Matt is going to talk about what needs to be put into these various reports, and then we'll talk about some issues. Now, timing requirements, just to give you an idea, timing requirements deal with two categories. New legal entities, those are ones organized and registered on or after January 1st, 2024. So that's a big deal. January 1st, 2024 is a date you have to look at. And they've got a short time frame. If you organize something after January 1st, 2024, that is a reporting company, you've got 90 days following the organization or registration to make your first report to FinCEN. And then you've got existing legal entities organized or registered prior to January 1st of next year, and they will have these entities will have until January 1st of 2025 to make the reports. Now, once you file an initial report, depending upon what fits your category, if you become aware of inaccurate information contained in a previous report or changes required in the information you have previously reported, you got 30 days to make that change. And for those of you involved in complex companies, you can see 30 days is not a long time to be able to be doing it. So again, it's something which really is going to end up being a compliance issue. Uh, and then because the reports must be filed with FinCEN, which is the enforcement side of the Department of Treasury, you got to do it properly because there are civil and criminal liability that attaches if you don't do it, as opposed to where we used to be in terms of reporting beneficial ownership information to banks. So this is a real significant change. It's a very significant change in terms of company liability as to how they need to ratchet up their compliance. And let's go quickly through a little bit of history. The AML Act of 2020. We were involved and given a seat at the table with the Commerce Clearinghouse in a wholesale negotiation over several years to be able to come up with an update to the money laundering statutes. And everyone was brought to the table, and people's concerns were put on the table, and there was basically a wholesale negotiation of what people needed and how they needed to do it. And for purposes of FinCEN, a lot of the things were concerns such as data sharing, cryptocurrency, innovation, risk-based compliance. But for the industry in general, expanded legal and entity identification was a point of contention, and the idea was to transfer legal identity data to the federal government as opposed to having it being resided with banking institutions in general. And that's and as part of the overall Money Laundering Act was the Corporate Transparency Act, known as the CTA, and it creates under the statute a database by FinCEN for the registration of legal entities, known as the BOSS. And they estimated that 2 to 5 million legal entities would be created each year going forward. The focus, as I mentioned, and what Aaron is going to go into, is on small corporations, limited liability companies, and similar legal entities. The coverage for foreign legal entities, and this is something for those of you dealing with foreign companies, is broader than that for domestic companies, something to be really careful about. The statute requires legal entities that are covered to register upon a formation or registration and to amend the reports, as I mentioned. And it's a major departure of where we were before, because before we were subject to the know your customer rules, where you go in and you get a loan from a bank, you get a deposit account from a bank, or another type of covered financial transactions where the counterparty is the financial service company. And all you really need to do is identify the legal owner of an entity, a person who owns more than 25% of the entity, and one management individual, and you give that to the bank or the other financial service company. Now you've got to give it to the federal government. And what happened was that finally FinCEN issued regulations implementing the CTA, and it requires reporting companies, including defined terms, domestic reporting companies and foreign reporting companies, to submit to FinCEN identifying information regarding a reporting company. And Matt's going to go into that. Beneficial ownership information, identifying beneficial owners, meaning all natural persons who own or control them. And again, that's an important term, which why we put it in red. Whether if you own or you control them, then you've got to identify them. And updated reports whenever a reporting company learns that a report previously filed is no longer accurate. Now, how many legal entities are we talking about? We're talking about a lot. In FinCEN's final regulations, they estimated that there are approximately 32 million reporting companies that will have to report. And they estimated that it will cost those 32 million companies $21 billion to comply with these new recording requirements. And on a go-forward basis, for entities which are formed after January 1st, 2024, about 5 million each year will have a new reporting requirement costing about $3.3 billion. Now, we actually think that the numbers here are lower than what they will actually be, because this talks about their estimates talk about initial reports as opposed to ongoing reports. And this will be, frankly, very, very significant on an ongoing basis. So the components of the regulations, what are they? Well, first of all, what is a reporting company? What entities are excluded? What exemptions are available? When must an initial report be filed, assuming in fact you decide that you're covered? When must it be amended? What information does the reporting company have to report about itself? What does a reporting company have to report about its beneficial owners who own or control the reporting company? And what does a reporting company have to report about company applicants, which is a whole new category, but it's important. And then, can you use a FinCEN issue ID in order to cut down the data which you're transferring to the government on a regular basis? The compliance burden. As I mentioned, as of January 1st, 2024, it revised its beneficial ownership regulations. And you can see the citations there. It's something which you should hold near and dear to your hearts if you're going to have to be responsible for compliance. And the regulations address 4 categories of legal entities that must be required to register with FinCEN, which again generally we're going to refer to as reporting companies, and they're segmented into 2 time periods for filing initial reports, and reporting companies that are organized under U.S. state laws or under federal law and operating in the United States. And so now that we've gone through just a general overview, I'm going to turn it over to my partner, Aaron, who's going to go into great and necessary detail about what we need to know for purposes of identifying compliance. Aaron?
Thanks, Joe. So the theme for my portion of this is going to be go big or go home, which I think is what FinCEN is trying to do with this rule. So with a few exceptions, most of what I'm about to tell you is going to be, this is broader than you might think. So let's start with the time periods. The timing requirements are going to vary depending on when a covered legal entity was organized. For new legal entities, meaning legal entities that were organized or registered with the filing office on or after January 1st of 2024, meaning they're not in existence yet, there will be a short 90-day time frame to register with FinCEN. The 90-day period begins with the organization or registration of the entity. For all existing legal entities, meaning those entities that were in existence that had organized or registered with a filing office prior to January 1, 2024, there will be a 1-year period to comply with the FinCEN registration requirements. So in other words, existing legal entities will have until January 1st of 2025 to file with FinCEN. Next. There's 2 general categories of reporting companies that have to file reports with FinCEN. FinCEN has called these categories domestic reporting companies and foreign reporting companies. The term domestic reporting company refers to any reporting company that is created under state or federal law by the filing of a document with the Secretary of State or similar office within the United States. The term foreign reporting company, on the other hand, refers to any reporting company created under the law of a foreign or non-U.S. jurisdiction that is required to be registered to do business within the United States by the filing of a document with the Secretary of State, a tribal jurisdiction, or a similar office of a state jurisdiction within the U.S. So in other words, formed outside of the U.S., but doing business within the U.S. and required to file something within the U.S. in order to do so. Next, please. So drilling down on these 2 categories. For domestic reporting companies, these are going to include any corporate form of a legal entity that's created by the filing of a document with a Secretary of State's office or a similar office operated by a state or Indian tribe. This is obviously going to include entities such as corporations, limited liability companies, and statutory trusts that are formed by a filing. Most of the time, this is not going to include sole proprietorships, partnerships, limited partnerships, joint ventures, and many trusts. But again, the key question here is, was it created by the filing with the Secretary of State or similar office? One question that has come up frequently already, and which the regulations do address, is whether a filing with the Secretary of State's office to obtain a license or permit will subject one of these types of U.S. corporate entities to the FinCEN regulations. And the answer here is no. So long as the filing in question is not a chartering or creation filing, it will not trigger the domestic reporting company coverage. Next. The foreign reporting company category is extremely broad. This category includes any corporate form of an entity created under the laws of a foreign jurisdiction that registered to do business in a state or tribal jurisdiction by the filing of a document with the Secretary of State's office or similar office. This includes not only corporations and LLCs, but also any other type of legal entity. It's important to note here that the scope of a foreign reporting company is much broader than the scope of a domestic reporting company. For example, a doing business filing requirement is far broader than the corporate formation rule governing domestic reporting companies. In addition, it is not uncommon for states to require partnerships, limited partnerships, and joint ventures to register to do business in the state. So this could sweep in many more companies. Although there are many factors that go into a foreign company's decision of whether to create a U.S. entity for its U.S. business, the relatively broader reporting obligations applicable to foreign reporting companies may incentivize some foreign businesses to do just that in order to conduct their U.S. business through an entity that will qualify as a domestic reporting company and be subject to less rigorous reporting. Next. Based on what we've said so far, you may be under the impression that the BOI regulations will require nearly every business formed or operating in the U.S. to make reports to FinCEN. I believe the number Joe highlighted was 32.5 million. However, this is not the case. While that is a staggering number, there are a lot of exceptions. Under the BOI regulations, the term reporting company excludes 23 categories of entities. This means that if a company qualifies under any of the excluded categories, it will not have to report to FinCEN. On this slide, we've listed 23 categories, which include highly regulated entities, such as SEC reporting, issuers, banks, securities brokers, investment companies, insurance companies, and so on. The rule also excludes entities unlikely to be privately owned, such as tax-exempt entities, public utilities, and government authorities. Next. There are two very important exemptions that we want to highlight. The first is the large operating company exemption. This refers to any entity that meets all of the following criteria. It must employ more than 20 full-time employees in the United States. It must have an operating presence at a physical office within the United States. And it must have more than $5 million in sales or operating revenue. With respect to the last prong, for a company that is part of an affiliated group of companies, the calculation may be made based on the consolidated sales or revenues of the affiliated group. The second important exemption is the subsidiary exemption. Subsidiaries of most exempt entities will also be exempt, so long as the ownership interest is directly or indirectly controlled or wholly owned by the exempt entity. Keep in mind that the application of this exemption is unidirectional. It looks downward in the corporate structure rather than upward. In other words, a parent's exemption will often extend to the subsidiary, but a subsidiary's exemption will not extend to a parent. Next. Once it's been determined that an entity is a reporting company, either a domestic reporting company or a foreign reporting company, and that none of the exclusions apply, The next questions are what needs to be filed and when. We'll address timing first. Under the BOI regulations, the initial FinCEN filing for a new legal entity or NLE is based on the date the NLE was created or registered. For domestic reporting companies and foreign reporting companies created or registered to do business in the U.S. on or after January 1st of 2024, those entities will be required to file their initial report with FinCEN within 90 calendar days of the date on which they are created or registered. With respect to changes to previously reported information, so these are reports that get filed after it opens on January 1st of 2024. If there are changes to that previously reported information, an updated report providing new information must be filed within 30 days after the triggering event. With respect to errors in previously reported information, a report correcting erroneous information in a previous report must be filed within 30 days after the date on which the reporting company learned or had reason to know of a prior report's inaccuracy, or within 90 days after the date of the initial inaccurate report was filed. And then finally, for existing legal entities, meaning domestic reporting companies and foreign reporting companies created or registered prior to January 1st of 2024, those entities will be required to file their first report with FinCEN by January 1st, 2025. And as mentioned previously, the BOI regulations establish a consistent 30-day requirement for the subsequent filings. This applies both to NLEs and ELEs. Subsequent filings will be triggered either by a discovery that a prior report was inaccurate when filed, or by a change in information that was contained in the previous report. Examples of the type of information that would require updates include changes in addresses, ID information, or any aspect of the beneficial ownership information. Next. That all may sound straightforward enough, but what fun would regulations be for us if they were so simple to apply? And so here we have an example for you of how these requirements can quickly become a massive headache for reporting companies. The BOI regulations require a new legal entity to file an amended report within 30 days of changes to the BOI or the date when the reporting company knew or should have known of an inaccuracy in a prior report. The reality is that NLEs may be required to make several successive filings because NLEs create their operating and capital structures over a period of time that could extend beyond the 90-day initial filing period. For example, let's assume that a new legal entity files its initial report within 90 days of its organization. However, the new legal entity doesn't establish its operating structure until after that initial 90-day period. In that case, following the adoption of its corporate structure, an amended report must be filed. Then, anytime a new senior officer is appointed, an amended report will be required. If the NLE engages in several rounds of capital raising, each round could trigger an amended report if the beneficial ownership percentages change or investors are modified. So at this point, we could be looking easily at half a dozen reports in the entity's first year of existence. So now let's turn to what information must be reported. There are two key categories of beneficial ownership information a reporting company must include in its initial report. First, it must specify the beneficial ownership information of individuals owning and controlling the reporting company. And then second, it must include information regarding what's called the company applicant, which is the person who organizes or registers the NLE. It is not necessary to identify company applicants for existing legal entities, thankfully, as that would be a massive undertaking. Next. Many of today's attendees will already be familiar with Know Your Customer or KYC regulations, which are similar in many ways to the BOI regulations. However, compared to the KYC regulations, the BOI regulations substantially expand what constitutes a beneficial owner. Under the BOI regulations, a beneficial owner means any individual who owns or controls 25% or more of the ownership interest in the reporting company, as well as all individuals who exercise substantial control over a reporting company. If the individual serves as a senior officer, has authority over the appointment or removal of senior officers or a majority of the board, or directs, determines, or has substantial influence over important decisions made by the reporting company. Next. The term senior officer is also a broader category than one might expect. Under the BOI regulations, it means any individual holding the position or exercising the authority of president, CFO, GC, CEO, COO, or, and this is where it gets broad, any other person, regardless of official title, who performs a similar function. Next. As I mentioned, a senior officer includes anyone who directs, determines, or has substantial influence over these important decisions. So what are important decisions? This concept also is broad. It includes the ability to direct, determine, or substantially influencing decisions in areas such as the nature, scope, and attributes of the business of the company, which could include the sale, lease, mortgage, or transfer of principal assets, the reorganization, dissolution, or merger of the company, major expenditures or investments, the selection or termination of business lines or ventures, compensation schemes, incentive programs for senior officers, so on and so forth. And then the list also includes a catch-all of any other form of substantial control over the reporting company. Next. So continuing this go big or go home theme, FinCEN went big with direct or indirect control as well. This casts a wide net that includes activities such as board representation, ownership or control of the majority of the voting power or rights, rights associated with any financing arrangement or interest in a reporting company, control over intermediary entities, arrangements or financial or business relationships with other individuals or entities acting as nominees, and any other contract, arrangement, understanding, or relationship. Next. At this point, I don't think anyone will be surprised to hear that ownership is defined broadly too. And ownership here refers to any equity, stock, or similar interest without regard to whether the instrument is transferable, is classified as stock or anything similar, or confers voting power or voting rights. It includes any capital or profit interest in a reporting company, regardless of whether the instrument is characterized as equity or debt, etc. Next. The BOI regulations indicate that an individual may directly or indirectly own or control an ownership interest of a reporting company through a contract, arrangement, understanding, relationship, or otherwise. And this includes joint ownership with one or more other persons of an undivided interest, through another individual acting as a nominee, intermediary, custodian, or agent, or through a trust. A trust may have different categories of a beneficial owner: the trustee, the beneficiary, and the grantor or settler. The BOI regulations provide some guidance on the calculation of ownership interests as well, but clearly an extensive due diligence may be required as each of these factors is going to take analysis. Next. Under the BOI regulations, new legal entities will be required to report information regarding individuals who organize or register an NLE. These, again, are referred to as company applicants. Note again that existing legal entities, meaning reporting companies created or registered prior to January 1st of 2024, do not need to report a company applicant. For those that do have to report, there can be a maximum of 2 company applicants. In the case of a new legal entity that is a domestic reporting company, the company applicant will be the individual or individuals who directly file the document that creates the domestic reporting company. And in the case of a new legal entity that is a foreign reporting company, the company applicant is the individual who directly files the document that first registers the foreign company in the US. Next. Importantly, for new legal entities, whether they are a domestic reporting company or a foreign reporting company, the company applicant includes the individual who is primarily responsible for directing or controlling such filing if more than one individual is involved. In a common scenario where a law firm handles the formation or registration of a new legal entity, there will often be two company applicants. First, the lawyer directing the creation or registration, and second, a paralegal or similar employee who's often doing the actual filing. And again, thankfully, there is no requirement to update reported information regarding company applicants for NLE. So that is a small silver lining. Next. The penalties for mistakes are severe. It's a crime under the CTA to willfully file false reports regarding a reporting company, or to willfully fail to file complete or updated beneficial ownership information to FinCEN. Violations can result in a civil penalty of $500 for each day that the violation continues or has not been remedied. And a violator may be fined $10,000, imprisoned up to 2 years, or both. The BOI regulations are far from clear regarding the degree of due diligence needed here. But suffice it to say, no one is going to want to have this responsibility. And technically, it is the reporting company that is required to file BOI reports. But by its terms, the potential criminal culpability extends beyond a reporting company to persons. In addition, each person filing a report must certify that the report is true, correct, and complete. So training is going to be extremely important to ensure that everyone who is involved in this process, whether at the diligence stage or the filing or updating stage, understands the requirements as well as the stakes. And now I will turn it over to my colleague, Matt Dickerson, to discuss the types of information that must be reported by reporting companies and what we know about how the reporting will be made.
Thanks, Erin. So now that we've talked about who needs to be included on a filing, let's take a look at what information goes onto a BOI report. So the general rule provides that an initial BOI report will include information on the reporting company, information on every beneficial owner, and for entities formed or registered on or after January the 1st, 2024, information on every company applicant. So the information must be submitted in the form and manner prescribed by FinCEN, and FinCEN is currently working on an online database known as the Beneficial Ownership Secure System, or BOSS. BOI reports must be submitted via BOSS, although it's not yet available to the public, and FinCEN has said it will not be available until January 1st, 2024. So what information do we need to provide on the reporting company? So first, the full legal name of the reporting company as it appears on its charter or certificate of incorporation. Any trade names or doing business as names, you must include all trade names that are used by that entity. Have to list a current address. So if you have a reporting company with a principal place of business in the US, then you would use the street address of that principal place of business. But otherwise, for example, if you have a foreign reporting company, you would use the street address of its primary location in the US where it conducts its US business. You would also list the state of formation. So for US entities, that's obvious, but for foreign reporting companies, this will be the US state or tribal location where the entity first registered to do business in the US. Finally, you would list an IRS tax ID. For a US entity, that will be its EIN. And for a foreign reporting company that doesn't have a US EIN, then you would use the tax ID number issued by the foreign jurisdiction and then list the name of the foreign jurisdiction. Next slide. So, next one, yeah. So what information do we need to provide for each beneficial owner? So you would list their full legal name, their date of birth, their residential address, and then a unique ID number from the individual. And this will typically be from a non-expired US passport, US state driver's license, or other US state or local government ID. If the individual does not have any of those US IDs, they may use a non-expired passport issued by a foreign government. The information needs to be provided along with an image of the document. So that would be the passport page or the photo ID page. So reporting of beneficial owners is subject to some special rules. Firstly, if an individual is a beneficial owner of an entity solely because of its ownership indirectly through an exempt entity, then the reporting company can identify the exempt entity in lieu of the beneficial owner. So in that specific scenario, you would not need to provide the beneficial owner's information. But this would not apply if that beneficial owner had other control interests in the reporting company, separate from its ownership through an exempt entity. And in that circumstance, the individual beneficial owner would need to be listed. Secondly, if the beneficial owner is a child under the age of 18, then you would not report information about the child. Instead, you would report the same required information about the child's parent or legal guardian, and you would indicate on the report that the information relates to the parent or legal guardian of that child. Finally, one of the 23 exemptions is an exemption for pooled investment vehicles. However, if the pooled investment vehicle is formed outside of the United States, then that entity would not be considered exempt, and you would have to provide information on the individuals who have substantial control over that entity. Next slide. So as Erin discussed earlier, a company applicant is the person that makes the filing with the relevant Secretary of State. And if different, the person that's primarily responsible for directing or controlling that filing. So there's a maximum of 2 company applicants. So in relation to the information you need for company applicants, firstly, for entities formed or registered prior to January the 1st, 2024, no company applicant data needs to be provided to FinCEN. This requirement only kicks in for new reporting companies that are formed or registered on or after January the 1st, 2024. Company applicants must be individuals. So even if they work for a law firm or another kind of service provider, the individual must be listed. So what information do we need to provide on a company applicant? It's generally the same information that must be provided for each beneficial owner, except for the address requirement. So if the company applicant forms or registers the entity in the course of their business, then you can list the street address of that business, such as the law firm or the formation services company, instead of the residential address. Next slide. So, as I'm sure you can appreciate, it's quite clear that the regulations require reporting companies to collect sensitive personal data relating to their beneficial owners and company applicants. And security concerns have been raised with respect to how this personal data might be handled. For example, that data might make its way through several different email inboxes between being disclosed by the individual and finally arriving on the BOI report that's disclosed to FinCEN. So as an alternative, FinCEN has created an option where the individual can instead apply for what's known as a FinCEN identifier or FinCEN ID. So to get a FinCEN ID, the individual, whether they're a beneficial owner or a company applicant, would make their application directly to FinCEN and disclose the same information that they would have otherwise been required to provide to the reporting company. In return, FinCEN will issue that individual with a unique FinCEN ID, which can be disclosed to the reporting company in lieu of the required information. The reporting company will then simply list the FinCEN ID on the BOI report in place of the individual's personal information. Another benefit of obtaining a FinCEN ID is that where a beneficial owner or company applicant needs to be listed on multiple BOI reports, the individual can simply use the same FinCEN ID across all of these filings. One important thing to note for anyone considering obtaining a FinCEN ID is that once you apply for a FinCEN ID, you must ensure that the information you submitted to obtain it remains accurate. So for example, if you change your name, you move address, or if you're issued with a new passport page, you must submit that updated information to FinCEN within 30 days. So in addition to beneficial owners and company applicants, FinCEN has also indicated that a reporting company itself can obtain a FinCEN ID when it submits its first BOI report. But FinCEN has not yet clarified how that number can be used, so we're still waiting for clarification from FinCEN on that. So with that, I'll hand it back over to Joe, who's going to give an overview of some recent developments from FinCEN.
Oh, thank you very much, Matt. Thank you, Aaron. That's an awful lot of material we've covered. And one of the things that I think the audience is sitting back saying, boy, in terms of our corporate structure, in terms of how we're organized, in terms of whether or not something might be an exempt subsidiary or whether or not we have to file because the entity is not a subsidiary because someone retains a right to be able to influence, substantially control the company, what do we do? And over the last several months, we have been submitting a host of questions to FinCEN now that these things are beginning to percolate up from the bottom up to the legal side. And one of the things I'm sure everybody's really happy about is FinCEN has gone into radio silence. They have not given us information. They have not responded the way we have asked. In the past, FinCEN actually was very, very helpful in terms of AML compliance and so forth. But in this case, they really haven't told us much in terms of clarification. And they keep saying the check is in the mail, we are going to tell you, but they have not done so. And as you know from what Aaron has told you and what Matt has told you, January 1st, 2024 is approaching. And this presents a real problem because they have said repeatedly, I think as recently as the day before yesterday, that the reporting system is going to be up and operating as of January 1st, 2024. But there's been no beta test. There's been no information regarding where do you go, how do you file it, what do the forms look like, what type of guidance is available in terms of questions that we have raised and we're going to continue to raise. But however, they keep saying this is going to happen. Now, whether that simply means you sending information into FinCEN and maybe at some point in the future they put it into the system that is not yet up and operational, it's completely unclear. But this is a real problem, could be a real stopping point, and yet you have to prepare because they keep saying this will now occur. Now, have they given us much guidance? The answer is no, not really. They have put together a beneficial ownership information document, which is available. They have put together a small business compliance guide, which have actually has some useful forms for very, very basic issues. However, the complex issues we've been talking about and the ones I'm sure many of you will discover, they haven't been addressed yet. One of the things that the firm is going to be doing in the near future is putting up a resource page for our clients and friends to address some of these issues as they come up, to address recent developments, to give you one-stop shopping to the extent that is practical, you being able to come up to speed and utilize this information. And also, hopefully, if you need us to help, we may be able to help, particularly in terms of analyzing structures and reporting requirements. That is in the, but I think we're going to end up with a great deal of ambiguity going forward because we're not going to know many of the answers. And I think Aaron indicated what is the degree of due diligence that you're going to have to report. Is the reporting requirements going to be similar to filing a SAR, which is when in doubt, file it. We're not quite sure whether it's correct or not, but we will do our best and we will file something. Again, things which need to be addressed by FinCEN. And again, I'm sure all of you are writing down saying, what about our concern, our transaction, our structure? And we're going to have to work through these things. Before we go on to copycat issue. Aaron, perhaps you can give us your thoughts about some recent issues or a major recent issue that has been raised by our clients.
Yeah, a few thoughts. So one, I just want to agree with what you were saying about the small entity compliance guide. I do think that some of our participants will find it useful as a tool to go through the initial analysis, but it really is a simplified version of what the regulation already contains, rather than providing a lot more information or context to help you understand what the various terms really mean. Or in some of these situations where the answer isn't clear, there's not a lot in there that will help you make those close calls. But it is a good place to start, and I would encourage participants to take a look at it if they're looking for more of a checklist form to help with some of the initial analysis that they're doing. The other thing that is coming up frequently with our clients is the next question down the road, which is, do we change the way that we are structuring our corporate organizations as a result of this, either to minimize the reporting burden or perhaps avoid the reporting burden altogether? Some of the things that we're seeing are discussions about, so it may be common, for example, to have a corporate framework where you have a very small entity at the top of the pyramid, and then below it sit all of the employees and everything else. Now, we discussed that revenue can be attributed to the whole affiliate group, but employees can't be attributed upward. So you may still have a situation where you have a large operating company exemption for the operating companies, but at the parent level, that's not available to you. So that's a real problem. And that's something that we're starting to get more questions about, is whether that's something that clients want to avoid in the way that they're structuring things. I also mentioned the issue with foreign reporting companies. Now, there are a lot of reasons why foreign companies may not want to submit additional information to the US government. They may already be submitting quite a bit of information with their registrations or qualifications to do business, in particular US jurisdictions, but maybe they don't want to hand over all of their ownership information that's considered highly private and not something that would be shared with their own governments. So there may be some reluctance there, and we may see some of our clients who have large foreign operations considering whether to just establish a new US operating entity through which to do business here that will allow them to have more control over the type of information that is being shared with FinCEN. And then, another issue that is going to come up much more frequently is the issue that those of us who work in banking have already been encountering for many years, which is that you have very private, high net worth individuals often sitting at the top of these companies who, for one thing, are very uncomfortable with the idea of sharing more of their personal information with the government. But for another thing, it may be very difficult to get in touch with in order to do these things. So when it comes to bank account opening, this has sometimes been an issue where you have someone who has a large ownership interest in the company, but they're not really there day to day. It may be hard to get a hold of them. They may be unavailable for weeks or months at a time. And with these tight timelines for reporting, that can be a real issue. So that's something that the companies need to be thinking about now, is who are your potential beneficial owners? Do you have ways to contact them over the next year to get the information that you need should you determine that their information needs to be disclosed in one of these reports? This is not something that you want to leave to the last minute. And then similarly to that, another thing that we're seeing is building into further assurances clauses and various corporate transactional documents requirements for beneficial owners to provide updated information to companies. As we discussed earlier, there's a requirement to amend your report, not only if you discover that something that you previously provided was inaccurate, but also if something changes, including ID documents or addresses. So there's a need to know who's behind your companies in these large corporate structures to keep track of that and to make sure that people are providing the updates when that information changes. Now, this is where I see huge problems because this is just one of thousands of items that corporations are having to keep track of. And when you add to that needing to keep track of individuals and all of the changes they may make to their personal addresses and everything else, it's just a nightmare in terms of compliance. So companies should be thinking now about how to set up their internal record keeping in order to keep track of this stuff and keep it current and updated. So those are a few of my thoughts. Joe, what else is jumping out at you?
Well, one of the things that people need to be aware of is Aaron talked about that subsidiaries are exempted, but there's a disconnect in terms of the definition of what a subsidiary is, in that it's a exempt entity. It's a subsidiary of an exempt entity that owns or controls the subsidiary. But that definition is different from beneficial ownership if someone exercises substantial control. And so the question becomes, can an individual who exercises substantial control, for example, you're an investor, you're a minority investor, but you've got a protection to be able to control certain corporate transactions. Does that destroy the exemption as a subsidiary? And there is not an answer to that. And that may mean that the company that itself is exempt must have complete control over the company, and the ability of giving corporate protections to investors is something that's going to have to be looked at very, very carefully in terms of the degree to which you give those corporate protections, or you may transform what you think is a subsidiary into a reporting company because of those protections, which may be demanded by an investor. And so again, this is where the analysis is going to end up becoming very complicated, where we're going to have to be asking FinCEN for clarification. The other thing, just as a note, there are some entities out there that are saying, well, we can help you do this, and we will be sending out a quarterly notification to make sure that if there's any problems, you properly file with FinCEN. Well, that may be a good thing, but you've only got 30 days once you're aware that there is a change before you make a filing. And so you may receive a notification on a quarterly basis, but you could theoretically already be in violation because you were aware of it and you did not include that within your compliance guidelines and your deadlines. So again, a lot of information to be thinking about in terms of putting it together. Also, too, privacy.
Yeah.
What do we do in terms of privacy? Who is going to hold the personal information and the other data? Is it going to be a third party? What if you're using a law firm? What if you're using another entity that is holding on to the information? How do you do that? What is the extent to which a third party is going to have a continuing obligation to help you out, to notify you, and to continue to provide you with information and guidance in terms of your compliance? And these are things, again, which are going to have to percolate down because the formation of a business company is usually relatively simplistic. It is no longer going to be simplistic, particularly for large companies that have got subsidiaries, and we're going to have to exercise care.
And Joe, if I can jump in there,
Yeah.
something that I think could be really troubling here is that situation where you have a third party that either can't be reached or is no longer cooperating, but you need information from them. Someone has to, verify that what is being filed is accurate. Now, as a comparison with suspicious activity report filings, which those in the banking industry who are on the call will be familiar with, the requirement is to provide the information that's available to you. This requirement is very different. This requirement is that you provide complete and accurate information. And so that imposes an extra degree of diligence on the reporting company to make sure that they're gathering the information. As we discussed, we don't know what the degree of diligence is that's required, what's reasonable, at what point that obligation wouldn't continue. But if you have an uncooperative third party, or if you're unable to verify certain information, this puts you in a very difficult position as the reporting company, as the person who is responsible for filing the amended report. There are going to be all kinds of challenges with this. And I am very hopeful, although, had hoped that it would be here by now, that we would have more guidance from FinCEN about what to do in these types of situations. Because as we mentioned, the penalties are so severe for getting this wrong. And, the intention to get it right may not be enough.
And I think to add to what Aaron's saying, if you are going to be using a third party to assist you, they're probably going to be very loath to give you an indemnification in case they mess up, because the obligation is on the reporting company, not on the third party provider to assist you. And we're coming close to the end, but one of the fun things is that there are certain states in the United States that love to copy everybody else, love to copy federal law. And we've got a copycat in the state of New York, which Matt is going to tell you about, simply in order to you can have a chuckle before we end up this seminar. So Matt, go right ahead.
Yeah, so very briefly on this, in late June of this year, New York state lawmakers passed a copycat bill, which was very much modeled on the Federal Corporate Transparency Act, which applies to New York LLCs only. It hasn't yet been signed into law by the New York state governor. The key difference, though, between the CTA and the New York LLC Transparency Act is that the beneficial ownership information will be publicly available. However, beneficial owners can apply for their information to be withheld from the public database in very limited circumstances where they can show a significant privacy interest. Examples include where they are participating in witness protection or certain whistleblower programs, but otherwise the intent is for the New York LLC database to be public. However, slight difference from the CTA, the consequences for failure to file a New York report are much weaker. A non-reporting entity is moved into delinquent status after 2 years, and to get back into good status, the reporting company would simply pay a $250 fine and file a catch-up report. So if and when this is signed by the governor of New York, the bill will take effect 1 year after it's signed.
And this is also being co-sponsored by the state of Delaware, which said you're not going to have this nonsense if you come down and organize yourself in the state of Delaware. So we'll have to see whether or not they lobby heavily to have New York do this. And maybe at the end of the day, it's not a good idea to incorporate in New York. One final thought for the folks here, and that is one of the things we have emphasized is you've got a year for companies that have been organized and registered prior to January 1st, 2024. For those of you who have got some planning that you're doing for the first part of next year, you may want to think about organizing a corporation prior, or maybe several corporations prior to January 1st of 2024, because then you've got a whole year to be able to get the thing organized before you have to file your initial reports. That seems to be clearly authorized under the statute, and may provide some relief from compliance issues, at least in the early part of the year. We want to thank you very much for attending. We've covered a lot of information. We're going to continue to be following this. We're going to be, as I said, within the near future, posting up a resource center. If you have questions, contact your trusted Dorsey contact. Materials are going to be sent out to you so that you can utilize them. And I want to particularly thank our panelists for the presentations. They've been putting an awful lot of time into this in order to keep up to date and also provide you, which I think is a very, very comprehensive summary of where we are and what's going to happen in the next couple of months. Thank you very, very much for attending. And we will be in touch if you have any questions or comments. You take care now and have a great evening.